What's up, everybody? Welcome back for another episode of Life and Law with Mike and Bill. What's going on, Michael?
Hey Billy. Hey Sid, what's up?
Oh yeah, we're here with our producer Lance as well.
Hello.
And a lot of good stuff to talk about today. We had quite a great weekend.
We did.
Michael and I started our weekend on Wednesday evening, headed down to Atlantic City, New Jersey for the New Jersey Association for Justice Boardwalk Seminar.
Wow, it's a mouthful.
It is a mouthful. They do it every year, but because of COVID, they have not done it live and in person since 2019.
Yeah, it was nice to get out and see people.
Did you have a good time, Michael?
I had a wonderful time. We had some excellent dinners.
We did have some excellent dinners.
yes,
and little teaser, as you guys know, we end every episode with a Mike Speaks rant, and something happened at dinner in Atlantic City when the dessert menu came that set Mike off. So stay tuned for that.
All right.
We're also going to talk a little bit about the NFL draft that happened on Thursday, Friday, and this weekend. And man, I am an Eagles fan, and I am excited.
Here we go.
Michael's going to tell me typical Philly, but we'll talk about that in a second because he's a Giants fan. And then the trial that I think half the world is paying attention to, the Johnny Depp versus Amber Heard and her countersuing.
You think it's really half the world?
I think a lot of people are watching this.
I don't think as many people are watching it as you think they are.
Well, we're going to talk about that a little bit, but we're going to focus on hearsay. If you've been watching the trial, you know hearsay has been a big thing in this trial. So we're going to talk about what that is and exceptions to the hearsay rule and all that good stuff. But let's start off.
What are we going to talk about first?
The NFL draft. Hold on. Should we play the Eagles fight song before we get started? Because
please.
They dominated the weekend. Howie Roseman dominated this weekend.
That's great. That's fantastic. You dominated the draft.
That's
great.
right.
Wow.
Hey, first off.
That doesn't put rings on your fingers.
Well, let's talk about. Well, we'll talk about the Giants first because they picked first. They had the number 5 and number 7 first round picks because they suck. That's why they had such high picks. Agreed?
No.
So why did they have such high? Why did they have such a high pick, Michael?
Because they finished lower than a lot of other teams in the standings.
And they had the Chicago Bears pick as well.
And they traded for a pick. That's right.
Let's look at their first round pick at number 5. They take Kayvon Thibodeau, a defensive end out of Oregon, who originally, when the college football season ended, was projected to maybe go 1 or 2 overall, slid because there's been some questions about his work ethic. Michael, what do you think about that?
I know we're going to find out about his work ethic. I don't have a problem with it.
You like the pick?
I love the pick. Love the pick.
Yeah,
He's
I think
a stud.
I think at number 5 there, you kind of have to take him. The kid is projected to be, like I said, 1 or 2. He's a defensive end, highly coveted position in the NFL. If you could put pressure on the quarterback.
And the Giants had so many needs that to go with, at the time, the best player available, that was clearly the best pick.
And then 2 pick. Go ahead, Lance.
And I think he's been a top prospect since he was in high school. I mean, he's been the number one prospect forever.
I'll tell you, and if he is good, I love the name. Kayvon Thibodeau.
Tibby.
He sounds like he's an ice hockey player, Thibodeau, doesn't he?
It could be.
Right?
That's funny you should mention
Got that French ending.
Thibodeau. It does have the...
Like that French-Canadian.
The EAUX at the end.
Yeah, it's like French-Canadian. But then 2 picks later, that number 7, the Giants go on the opposite side of the ball.
No brainer.
Offensive line, Evan Neal out of Alabama.
You got the stats on him, Bill? How big is this boy?
He's a big boy.
He is huge.
He is a big boy. You know what? I don't have him handy, but let me do that for you, Mike.
6'7", 330 or something like that.
To me, this is the point where the draft gets easy. Okay, you need an offensive lineman? Look at Alabama. If the kid played for Alabama, played for Nick Saban, you know he's got to be good.
So you're right. Alabama with Nick Saban, that's the way to go. That's what the Eagles did last year. But he is 6'7", 351 pounds. 6'7". But you know what? Now let's talk about my team. Okay, let's talk about the Philadelphia Eagles draft because you want to talk.
Can we keep it reasonable though?
Well, you want to talk about a big guy.
Yeah.
Him being 6'7", 350. How about what the Eagles do with their first round pick? They move up 2 spots to number 13 and they draft defensive tackle out of Georgia. Another big program, best defense in the league.
National champion.
And the best defense in the country last year. They get defensive tackle Jordan Davis, who, are you ready for this? 6'6", listed at 340 pounds, but played actually at 360 in some games. He runs the 40 in 4.78, I believe, was his 40-yard dash.
So he's still smaller than Evan Neal, right?
Do you realize how fast a 4.78 40 is for a man who is 6'6", 340 to 350 pounds?
Yeah, that's fast for any human being, but a man of that size, it's lightning speed.
Imagine getting hit by that. Not only is he running that fast, but he's going to hit you too.
When if you're at yard 35 and he's running a 40.
Oh man.
Well, how about this? He runs a 4.78. Do you know the greatest receiver of all time, arguably Jerry Rice, ran about a 4.7 40?
Okay. You can take off the word arguably.
He is the greatest receiver of all time.
Then why'd you say arguably?
Because,
there's no argument.
Because that wasn't the point of the conversation, because then it gets diluted. My point was,
okay,
you have Jerry Rice, who is one of, if not the greatest wide receiver of all time, and he basically is as fast in a 40-yard dash as Jordan Davis, who's 6'7", 350 pounds. That is crazy.
Crazy fast.
Crazy.
Yeah.
And then, this is why Howie won the draft.
Howie won it.
Howie won the draft. My
Howie
man, Howie. Yeah. Should we start the chant?
No chance.
So after they draft Jordan Davis at number 13, they shock the world. They trade their number 18 overall pick as well as the 101st pick in the third round to the Tennessee Titans, and they get themselves a stud wide receiver in A.J. Brown. This guy does it all. He catches contested balls. He doesn't drop anything. His yak. Do you know what yak is, Michael?
Yeah, yards after catch.
Yards after catch. He has the ability to block.
You insult me.
And the beautiful part is he's already friends with the Eagles quarterback, Jalen Hurts.
Well, that's important.
They had been practicing together.
Gotta be friendly
in the offseason.
If you're not friends with your quarterback, you can't possibly catch anything that he throws.
But Howie Roseman wasn't done. He wasn't done. He then drafts, hopefully, Jason Kelsey's replacement, Cameron Jurgens, out of Nebraska, a center in the second round.
I'm a big Nebraska fan, so
you need an offensive lineman.
This guy is
go to Nebraska.
Yeah,
he is.
I mean,
the real
Nebraska,
deal.
Oklahoma. Wait, all those boys out there, they're eating corn and big steaks.
And he can actually move to the tackle position or guard position.
But I was listening to what Howie Roseman said over the last few days. He can, and they're going to work him a little bit at right guard, but the goal for him is to become the center of the future.
Right.
Jason Kelsey, who they've been relying on not only as the best center in the league, but almost as a guy to evaluate talent, said that this is his favorite center that has come out of college in the last 3 to 5 years. They used him, Kelsey, they used him to evaluate centers. This guy looks like Jason Kelsey. He has the ability to move. He has the athleticism.
He's great
smart,
size, too.
He's intelligent. But even though...
Is he done yet? Is he done yet?
Hold on. That's what I was going to tell you.
You were going to tell me. Howie wasn't done.
He still wasn't done. Not only does he get Jordan Davis, an absolute beast in the center of your defense, playing D-tackle, then he drafts Cameron Jurgens out of Nebraska. He makes the trade for A.J. Brown. But then, in my opinion, the steal of the entire draft.
I'm going to write this one down.
It's a steal.
Steal of the draft. No, in the third round at number 83, they take Nakobe Dean, linebacker out of Georgia. Again now.
I like that kid.
Georgia.
Yep.
Nakobe Dean was projected to go in the top 15 picks. He was even invited to the NFL draft by the NFL.
What happened? Why did he drop to the third round?
So the rumors out there were that he had an issue with his pec. Apparently, he strained his pectoral muscle training for his pro day. There was some argument about whether or not he needed surgery. He didn't need surgery. But apparently, and this is what I don't understand, an independent doctor sent a letter to 32 NFL teams, all 32, telling them that he examined Nakobe Dean. He does not need surgery. It's a pectoral strain, and that he would heal and he'd be fine. The Eagles had their
announcement. Given that, still, he falls to the third round.
He still falls.
I would have grabbed him sooner than that.
I mean, we've seen this before in the NFL draft. Guys will fall. I remember Randy Moss and Aaron Rodgers. Guys that fell for really no reason. I think
Randy was because of marijuana.
Yeah, but did it impact his play at all?
No, same thing happened with Larry Tunsil a couple years ago. Remember, someone posted that picture online of him smoking weed out of a gas mask or something, and his stock dropped. Yeah. But yeah, it's interesting. Hopefully, the Eagles stole this guy because everything I'm reading about him is not only is he a great football player, not only was he the leader on the best defense in the country for the national championship Georgia Bulldogs, apparently he's got a perfect GPA in mechanical engineering.
Really? Wow.
So he's just
That's
a
impressive.
really impressive guy. So the Eagles win the draft. And in my opinion, Mike, I'm going on record.
What does it mean? Let's sum it up now.
They are now the favorite to win the NFC East. Not the Giants, not the Commanders, and certainly this is who they had to leapfrog.
So they are the
Dallas Cowboys.
They are the favorite to win, arguably, the worst division in football.
I don't think they're the worst division in football anymore.
I think they were last year.
It'd be a better division if the Giants were better.
Oh, he took a shot.
You dog.
He took a shot. But this isn't legal hands to the face with Bill Colarulo.
Sounds like it.
This is life and law with Mike and Bill.
Sounds like it.
So we're going to move on. Although,
So they win the division at what? Maybe 8-8, 9-7.
Well,
no, we got to go 8 and it's a 17-game season now, right?
it is. I think the Eagles go at least 10-7 this year.
10-7.
At least. But here's the problem, and then we'll move on. What I'm saying, what you're saying, what all these analysts and draft experts are saying, nobody has any idea. And you won't know
No
for
clue.
a couple years.
No clue.
But that's why it's comical when you look at this, and I'm kidding a little bit saying Howie Roseman won the draft. He had a good draft, but you don't know if it's actually a good draft for about 2 to 3 years. You just
but
don't.
you know what? And let's give some credit to other people too. It's not just Howie Roseman. I mean, he's got a team of advisors and scouts and all his football people, but he's the one who gets all the credit.
Well, he's also the one that gets all the negative stuff.
That's right.
too.
He's got to be the one who takes the negative when it comes along, right?
Yeah.
So
So
you know what I can't stand about the draft the way it's become. If you watched any of it, I mean, there's got to be an age cutoff for appearing at a live event dressed in your favorite team's jersey. And this one guy he looked dressed as a Viking. I mean,
You weren't there, Mike?
He looked like he was 62 years old. I mean, come on, man.
You wouldn't do that?
Get a life.
You wouldn't do that?
No, it's got to be.
Hey, to each his own, man. Whatever makes people.
There's got to be a cutoff. There's got to be an age limitation.
Painting your face. And,
Yeah.
Yeah, whatever makes people happy. So we're going to switch gears and we're going to talk about a trial that I think a lot of people are watching, and that's the Johnny Depp versus
Johnny
Amber
Depp. I
Heard.
like Johnny Depp. You
Amber
like Johnny
Heard
Depp?
versus Johnny Depp.
Love Johnny Depp.
Johnny Depp, boy. Pirates of the Caribbean. Better than that. The Charlie and the Chocolate Factory.
Yeah, what's your favorite Johnny Depp movie ever before we get into the trial?
Oh, I'm going to forget the name of it. The one where he played the... what was the name of that movie?
What's eating Gilbert Grape?
No. He was an author.
Secret Window.
Oh, yeah.
Is that what it
Secret
was?
Window.
It's a
It was
great
a
movie.
very good movie.
That
That's
was
a-
spooky.
Yeah, it was a
Yeah.
great movie.
Yeah, don't give away the ending, but
I
that's a
won't.
pretty
I
good
won't,
movie.
but I like that one.
That's
Yeah.
a pretty good movie. Johnny Depp's been in a lot of good roles. Now, you mentioned Pirates of the Caribbean. Is it Caribbean or Caribbean?
It may be.
Which one?
Both.
Lance, you got an opinion on this?
I think it's both.
I think it is too. I think it is too. But I say Pirates of the Caribbean.
Well, you're special.
So, but anyway, I want to disagree on one thing, and then we'll
What?
get into the trial. I didn't like Charlie and the Chocolate Factory with Johnny Depp. I prefer the Gene Wilder version.
Gene Wilder.
Willy
What a
Wonka
pro.
and the Chocolate
Yeah.
Factory.
No, but Johnny Depp did
No.
a nice job.
I liked them both.
Wait, I'm wrong. Which one? Johnny Depp was Willy Wonka
No.
and the Chocolate Factory.
No,
and
no,
It was the
no,
opposite.
no.
It was the opposite.
Gene Wilder was Willy Wonka and the Chocolate Factory.
And Johnny Depp
And by
was
the way,
Charlie and the
by
Chocolate
the way,
Factory.
Sid, it's chocolate.
Chocolate.
Chocolate, not chocolate.
There is the
Chocolate.
the New York coming out. But let's go. We're attorneys, so we wanted to talk a little bit about something that's in the news. Now, we're going to wait until the actual verdicts come out in this trial to talk about the trial itself. But if you've been following along, a lot of legal terms are getting thrown around, but one that's being used a lot is the word hearsay. And in fact, there's some videos floating around on social media where Johnny Depp is actually starting to anticipate hearsay objections while he's testifying,
Right.
which is kind of funny. He's testifying and then he'll pause and even look around the courtroom. No hearsay objection. So we want to talk about hearsay because everybody's heard it, whether you've watched TV or you've seen these Law and Order shows. The word hearsay is always thrown around. Objection, hearsay, objection, hearsay. But what is it? And is it always inadmissible?
No, it's not.
No, it's not. So what hearsay is a statement that is made by a declarant that is not testifying in the current trial or hearing. So meaning that someone said something who's not there testifying or not there testifying at that time. And this is the important part. It is being offered to prove the truth of the matter asserted in the statement. So what does that mean?
It's a rumor.
So, yeah, but it's a rumor that's being used to say that something is in fact true. So if I was testifying and I said, yes, Mike Aloi went to the Friendly Food Mart yesterday. They said, well, how do you know that, Mr. Colarulo? I said, oh, well.
He told me.
Well, yeah, Drenna told me Mike was going to the Friendly Food Mart. Well, that is hearsay.
Well, yes.
I'm hearing it from someone who says it, and I'm trying to say, well, then it must be true that Mike went. Now, that's a really basic example of it. But you always hear the objection hearsay when people are talking about something that someone else said. So Mike said, in the simplest terms, it can be a rumor. But there are exceptions to that rule. And a lot of times you may hear objection hearsay, and then the attorneys will go sidebar, and the judge will still allow that testimony. So we wanted to talk about some of the exceptions. And these exceptions usually fall into two separate categories. One...
You got it narrowed down to two.
Well, two categories.
All right.
One is when the declarant, meaning the person that made the statement, is unavailable, meaning they cannot come to court for whatever reason. They may be dead, they may be unavailable, they may not know who this person is. And the other is when it doesn't matter when the declarant is available or not. So let's talk about those first, where it doesn't necessarily matter on their availability. It's not dependent on their availability. And one of the ones that's very easy is a statement by a party opponent. So what does that mean?
A party to the case.
Exactly. And it's a party opponent. So if I was suing Michael, that means I am the plaintiff and Michael is the defendant. And let's say it was a car accident case and Mike, you rear-ended me and you got out of the car and you said to me, I was speeding and looking at my cell phone. That's why I didn't see you.
Or better yet, if I said to Sid, I was speeding when I hit Billy, then Sid could come to court and testify, Mike told me that he was speeding when he hit Billy. That is hearsay, but it's admissible hearsay because I am a party to the action. Am I right?
Very good, Michael. Very good.
Sid? You pick up on that?
If I was in court and I used the name Sid, would they still take the
Yeah,
Absolutely,
probably.
yes.
Probably not. But that's an easy one. When a party opponent makes something, and we've tried cases here, and a lot of times when I'm trying a case, I may even stand up at a certain point in the trial and read in admissions that the defendant has made at a deposition or something along those lines, and that's not hearsay. That's number one, it's testimony, deposition testimony, and it's also because it's made by a party opponent.
And you are challenging or you are bringing to light the prior inconsistent statement, which is also on our list.
That is another
exception.
There
are so many.
If there's someone who is testifying and you have something that would be an inconsistent statement, then you can talk about that to try to impeach their credibility or something along those lines. But these are ones that are interesting, and this is what they kind of teach you in law school as well. And this doesn't matter whether whether the declarant's available or not. Do you remember the term present sense impression? Do you remember that one, Mike?
I remember it.
So this is an exception to the hearsay rule, and a present sense impression is a statement.
State of mind.
Exactly. It's a statement describing or explaining an event or condition that's made while or immediately after it's being perceived. So the argument here is the reason that they allow that hearsay exception is because they feel that the person didn't have an opportunity to deliberate or fabricate it because they're watching it. They're watching it saying that car is speeding, or they're watching it saying that person's on their cell phone.
So it's inherently reliable.
Because it's a present sense impression. Now, sometimes there's another exception that gets confused with present sense impression. And that is the
excited utterance.
Yes, Michael. Excited utterance. Now, I'll give you the definition and then we'll give you an example. But an excited utterance is a statement relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event, or without an opportunity again to deliberate or fabricate. So if I'm on the stand and I'm testifying and I'm telling about a story where, and then Lance came running over to me and he was shaking and he was screaming that he just saw John murder Bill. That may be an excited utterance exception to the hearsay rule, because when Lance did it, he was still experiencing the stress of watching that occur. He didn't have an opportunity to deliberate and fabricate. So that's another one, Michael.
Yep.
And then
what about one of my favorites?
What's
the
that?
Dying declaration. Tell us about that one, Billy.
Well, I wasn't going to get there yet because
I want to hear about it.
That falls under the other category where the declarant is unavailable.
Well, let's keep it moving.
So we will keep it moving. One more, and then we'll move to your dying declaration, is if a statement is made for the purposes of medical treatment or a medical diagnosis, they tend to usually allow that as an exception to the hearsay rule, because if it's describing their medical history, it's usually made what they think in good faith as it's pertaining to their diagnosis and treatment. But what Mike's talking about is a dying declaration. Why don't you tell us about that one, Mike?
I wanted you to tell us about it. But there's a presumption that if someone utters or says anything while they are if they're near death, they're on their deathbed, then there's a presumption that they're not in a position where they're able to fabricate or lie. So whatever they say is deemed believable and honest. I don't know how I feel about that. I think if you really gave it some thought.
I mean, that's the way to go out. Just lie about something and really
Exactly. This is what I was
cause
thinking.
all kinds of turmoil.
Right? You could really, really screw things up if you had it in for somebody, and just if you had this.
Yeah, you could. People can't see you pointing to your head on the podcast here. But yeah, Mike, the dying declaration is one where the declarant is obviously unavailable because they're dying.
They're dead.
There's some other exceptions that fall into there, testimony in prior hearings or things of that nature. And the interesting thing, the dying declaration, the person only has to believe their imminent death.
Right.
So not necessarily.
They don't have to die.
Yeah, they could just have been a victim, and but they thought that they were dying. There's also the statement against their own interest, the statement of a personal or family history. There's a million. I shouldn't say there's a million. See, this is what we have to always clarify. There are several hearsay exceptions, but those are the ones that you kind of come up to most often. Now, here's where it gets super complicated, and we won't get in that one. Hearsay within hearsay.
Double hearsay?
That happens a lot as well. You may have a document, because a document can also contain hearsay, such as a police report could contain hearsay.
Wow. Now, wait a minute. A police report?
Well, a police report would fall under a hearsay exception, because things that are in a police report are potentially business records, which is
an public record,
which is an exception to the hearsay rule. But this is what I mean, hearsay within hearsay. There could be a witness who was maybe dying at the scene of the accident, who made a dying declaration within the police report. So the police report is admissible because it's an exception to the hearsay rule. But what about the hearsay that's within the document?
Well, what if, now wait a minute though, what if there was a big car accident and there was a person who thought they were dying at the scene of the accident, and they made a statement to one of the parties to the accident, and that person spoke to the police and they wrote it all down?
So that would be...
Is that triple hearsay?
Be triple hearsay. Arguably, the police report is hearsay. Well, no, there's an exception. It is a business record, so that could be admissible. The statement made by the defendant, that's a party admission. But if they're testifying about something that they were told by the person dying, now you have the dying declaration, the party admission within the police report.
You know what this makes me think about?
Quadruple hearsay?
No, it just makes me think I really, really should have gone to dental school.
I thought you were going to say super secret probation or something.
I should have gone to dental school.
But anyway, if you have questions, this is why you need an attorney. There are so many nuances to the hearsay rules and the evidence rules. And like anything pertaining to the law, there's never usually a clear, bright line answer. If there's a hearsay objection, usually the judge will take the lawyers to sidebar and they could argue why or why not something should be admissible, and it ultimately comes down to the judge's discretion of what they feel should be admissible. And then if you felt that the judge erred in any way, you may have rights for an appeal. You may be able to appeal a decision by a judge or a jury based off of certain evidentiary rulings that were made during the trial. So a lot of these things...
What a system.
Yeah, a lot of these things happen. And what we do a lot as lawyers is we try to deal with as many evidentiary issues as we can prior to trial so that there are not several objections that happen in front of the jurors, because the jurors tend to get annoyed. If you're watching the Johnny Depp trial, how annoying is it when the witness is on the stand testifying and you constantly keep hearing the other attorney say objection, objection, objection?
It has an effect on a jury.
It really does.
Because the jury starts to think, this guy doesn't know what he's doing.
Didn't one of the attorneys object to himself?
He did.
Yeah.
He did. He objected to his own question. But see, Mike said, does the jury start to question, does the lawyer know what they're doing? What I've always been concerned about is, if you object too much, does the jury start to think, what are they trying to hide here? What are they trying to prevent us from hearing? There's clearly something they don't want us to know. So you got to just be careful. And that's why we do a lot of what we call in limine motions. And an in limine motion is a motion that is filed before the trial so that the judge can make these evidentiary decisions about what is admissible and not admissible outside the presence of the jury. But there are times where you can't avoid it. But let's move on, because we want to get to the segment of the show that we call Mike Speaks. So I told you guys that we were in Atlantic City for the New Jersey Associations for Justice Boardwalk. Man, that is a mouthful. I'm just going to use the acronym.
We
NJAJ Boardwalk Seminar.
And we were having dinner.
And we were having dinner at a lovely restaurant.
Which one?
We were at Angeline by Michael Simon at the Borgata. I've had the benefit of being there a couple of times. It does not disappoint. The key to a good restaurant, Mike, is consistency.
Absolutely.
There is nothing worse than when you have a great meal and you go back and it tastes different.
Yep.
You can't change what chicken you used or bacon.
Isn't that really the key to life, Bill? Consistency.
You're right. People want to be able to rely on whatever they're doing that it's going to be consistent.
Profound. Consistency. Yes.
So we consistently
So we're having a lovely dinner at Angeline's.
Lovely. Mike was a little bit of a bump on the log, but
no, that's not true. We were a party of eight people, eight people.
There were 8 of us. We had a lot of the Grungo Colarulo crew with us.
Sid, you've been out to dinner many times, with other people, and I don't care, who did the invite or what the event's all about or who's picking up the tab. That has nothing to do with what I'm about to say. But there's sometimes the one person in the group, when it comes time for dessert, says, I don't want anything. Oh, you know what? I'll get can you give me the New York cheesecake to go?
That gets Mike angry.
To go where? Wait a minute. Are you telling me that you're tired of me? Or, dinner's over as far as you're concerned. You don't want to spend another minute in our company. You want to take your dessert back to your room or back to your house and eat it later on? No.
It's a violation, according to Mike.
This is completely unacceptable. It's insulting to your company, your guests, or your companions. I can't see it. It's happened to me several times.
So it actually
happened. And I will not stand for it. It almost got into a fight about it.
Mike, you don't fight. You're a teddy bear. We love you.
Okay.
But this happened a couple years ago. We were out to dinner.
Yeah.
And a friend of ours who always does this when we're out
got
the dessert to go, and Mike lost his mind. I don't think he does it anymore. At least when you're not around. But I talked to him about why he does it, and it's actually brilliant, and I may agree with him.
No.
He gets the dessert to go so he can bring it home to his significant other.
No.
Mike,
if he wanted her to have the dessert, he should have brought her to dinner.
All right, relax. You're going to knock the microphones off.
He's going to break everything.
Come on. First of all, how many desserts are going to travel well?
Let's true.
Keep that in mind.
But
not all desserts travel
What is
well.
the difference between taking out a dessert at a restaurant and taking out a dessert at a shop, like a cafe?
Well, Mike's saying that we have agreed to go to.
That is a stupid question.
We've agreed to go to dinner. We've agreed to go to dinner together.
Right.
So
you've made a commitment to the people that you're with, that you're there. You're going to have a lovely meal. You're going to enjoy yourselves, and that includes dessert.
Let me ask you a question. Would you be insulted if the dessert menu came and you, and a few others were out, and everyone ordered dessert, including me, but I got a second dessert to bring home to my significant other. Is that still a violation?
No. Yes. It's not a takeout restaurant. You're at an elegant restaurant, a 4-star, 5-star dining experience. It's not for takeout. You want takeout? Go get a frickin' cheesesteak and a bag of fries and a tasty cake to go.
You know, you just reminded me of cheesesteaks.
Yeah.
You know what we did not do this year that we do every year we go down to the Boardwalk seminar?
We go to the White House?
We go to the White House. We always end the weekend at the White House sub shop with either cheesesteaks or hoagies. And if you haven't tried White House, man, you don't know what you're missing. And we got to get back down there, Mike.
Maybe we'll have to take a special trip down there.
We got to get back down there.
Look who's inviting himself.
Yeah, Lance wants in. And he's going to get his dessert to go to bring home to his wife.
No, he's not.
Well, that is a full 30 minutes. We got to calm Mike down before he has a heart attack.
Let me write that down.
Yeah, it was a long time. So the summary of today's podcast is the Eagles are going to win the NFC East. The Giants
and
Super Bowl.
There you go. I was waiting for a Philadelphia fan to say it.
The Giants are going to continue to be subpar. They got a problem at quarterback with Daniel Jones.
We rating down the bet right now.
Yeah.
What are we doing? They played twice this year.
The other thing you learned today was all about hearsay. Obviously, there's more exceptions to the hearsay rule, but really the gist of that whole discussion was just because something is in fact hearsay does not mean it is inadmissible in a court of law. There are exceptions to that rule. And then finally, if you're ever out with Mike to dinner, do not get dessert to go.
It will not happen.
But as always, thanks for listening. Be sure to like, subscribe, share, comment. You can check us out. We're on all your podcast platforms. We also upload the video link to YouTube so you can see Mike's beautiful face. And Michael, thank you as always, my friend.
Thank you, Billy. Thank you, Sid.
Thank you.
Thanks for producing, Lance. We'll talk to you guys soon.